Jeetendra Sharma is the best person to do justice with this topic of end of life support. I know him for almost 2 decades and he is one of the most promising young intensivists of the country, Dr. Jeetendra Sharma.
For giving a ground for the understanding of our topic. Almost similar this type of the case scenario जहाँ पे patient का cancer है. एक example है. I started one of the prototype kind of this thing. इसको बहुत सारी इलाज चल गया है. अब किसी दिक्कत में आता है, जरूरी नहीं है कि वो बड़े अस्पताल में जाएगा. हो सकता है वो किसी जनरल प्रैक्टिशनर के पास भी जाए. और in a good faith, what we are giving our services meant for the curative disease, we started the services to that particular patient and probably he may or may not be benefited. What we are talking about this type of case scenario. So this is the ground and what is the objective of this talk which I deliver with this background is commonly used term which we come across when we deal such type of situation. Principle of end of life care, legal aspect of end of life, landmark judgments which actually play important role when we practice end of life care, propose the documentation so that it can be a safeguard and key messages. A commonly used term first is the palliative care. Palliative care is term used when our care is directed from curative to the comforting. So that's whatever we do the patient is actually to relieve their symptoms, to relieve their agony and to relieve the some disease process which actually making the patient's lifestyle bad. Second is the futility of care. At times these are the confusing words, these are the confusing terms which have been described in the different evidences of the court also. So just we have to understand what they are talking about. Futility of care, when we think whatever we are doing for the patient is not going to help. What we are doing for the patient is not going to affect the outcome in terms of the morbidity and mortality. That is called the futility of care. End of life is one of the methods which we understand now. What care to be given to these type of the patient? Doesn't mean if something cannot be done to these patients, we stop caring them. Then what care needs to be done? If we cannot go for some curative care, then what care they are requiring? Withholding of the life support, where when it's required, then you are not giving the life support. That is the one aspect of withdrawing of the life support. Most of the things is described in the landmark judgments. And the most important is euthanasia. Euthanasia is a Greek word that means good death, where you start ending of your interventions toward the ending to the life to relieve the pain and suffering. That is a commonly used euthanasia, and that is at this moment most confusing term which I would request. Of course, the legal is divided into two parts. One is active, one is passive. Active is the act of commission, passive is act of omission. So whatever these are the confusing terms, I will discuss coming in our coming slide, but I would request in our clinical practitioner, try to avoid these terms. Please try to avoid these terms, whatever in the form, even euthanasia, try to avoid, because most of the judiciary get confused with such type of the terminology and how it is affected our practice, where the practice is governed by the judiciary. I will give you an example also in the later part of the slide. Terminal illness is the illness by nature, it is terminal. Say for example, widespread gallbladder carcinoma is a terminal illness. Patient may be relatively better, but it is a terminal illness by nature, and sometimes the patient is also terminally ill. Brain death is another term. It is not really confused with the terminal illness or terminally ill patient. It is all together is a different thing. It is a completely a kind of a death. Previously we were using this brain death certification for the transplantation of the organ only. Now it is even a mandatory to really certify the brain death under the Form 8, even without the organ transplant. So why I am describing all these terms, it is going to really affect when it comes to your clinical practice. Should I offer end of life care to the brain death patient or not? No. Brain death is altogether a different thing. And the vegetative state, again, most of our judgment is directed towards the vegetative state and the persistent vegetative state, which is a quite different stage, which is a quite different situation, which I am talking about that. I narrated one scenario in my beginning of the talk, widespread carcinoma presented with the significant breathing difficulty and the blood pressure is going down and you require a mechanical ventilation or a medication which is required to sustain the life and many more interventions. So this is the difference from the vegetative state. That's why whatever we are talking about that becomes a really questionable in the vegetative state, and the brain death, it is not really at all applicable what we are talking about. So please keep the brain death concept different from the what we are talking about. What I mean to say, as an intensivist, what I mean to say, I am talking about this type of the patient who is in the ICU on the so many life support in the form of the ventilator, sometimes maybe a ECMO, different drugs to increase the blood pressure, and maybe many more organ support in the form of the dialysis to support the kidney. I am talking about these patients. They may live for days, maybe a week's time. They cannot live for the years or 2 years, which most of the judgment actually directed towards the this type of situation, judging in this situation. So what I mean to say? I mean to say we are talking about today is foregoing of life support therapy. Nothing to do with the euthanasia in any form, whatever active or passive. We are just talking about foregoing of the life support. In these situations, the further our talk is based upon. Can we practice end of life care in India? I want a response from the audience. What is our understanding at this moment? Can we practice end of life care in India? Yes, no, don't know? Yes. One is no. Few say yes, obviously. I take this question in the end of life I talk. But of course, this is the question, can we practice end of life care in India? And when we say the medical practice based upon the three main principles. One is the basic science, or what we can say is a pure science. Another one is the ethical principle, and third one is the legal allowance from the law of land in that particular country or area. That is the three domain under which we are practicing, and based upon that we try to give the answer from that. Now it comes to we assume we are practicing end of life care. Again, I am not confusing the house. What I mean to end of life care is when we say ये पेशेंट अब नहीं बच सकता, हम कर रहे थे, काफ़ी सालों से कर रहे थे, कुछ समुदाय में, कुछ रिलीजियन में, दिस इज वेरी वेल एक्सेप्टेड नॉर्म्स. व्हेन इट कम्स टू अ जैनिज्म, देयर इज अ प्रोविजन ऑफ संथारा. दैट इज नॉट इवन अ डिजीज प्रोसेस. Even a normal life, it is taken as a process of dying, is a sankhara. I am talking about that part when they think the patient is not going to be helpful for the curative aspect, curative intervention. Now our care is directed towards the comforted. That is what we are talking about, the end of life principle. And that the first end of life principle, this is important because the last segment of my talk is a documentation, and this is the foundation of the documentation. We must know what is the principle based upon we direct our documentation to fulfill these principles. First and foremost principle is autonomy. Autonomy means self-determination. It is the person's own body who is actually controlling his own body. His or her wishes is the prime when he is in the capacity to take a sound decision. That is the autonomicity over there. Sometimes it can be shifted to the surrogate, what we call as the surrogate judgment, in the best interest of the patient, what he would like when he reaches that status based upon what is his or her previous association with the patient. But autonomicity is the prime for the all medical practice, but more relevant in the end of life care part. Second is beneficence. Whatever you do in the best interest of the patient, you are allowed to do in the certain situation. It is not a, please be really very clear about that. End of life doesn't mean don't do anything. जो हम सोचते हैं कि अच्छा अब इसका कुछ नहीं हो सकता, छोड़ो छोड़ो जाने दो, कुछ मत करो इसका. End of life is not that. End of life is even what is really helping the patient. Even it is not related to the high technology versus lower technology. If patient is suffering from the breathlessness, from the pulmonary edema, doing the echo and X-ray can be considered as a end of life care, because based upon that you will relieve his or her symptoms under the heading of beneficence, because you try to help the patient. Definitely doing the maybe your genetic study or maybe lipid profile may not be really necessary at that point of time. That's why it is not comes under the beneficence. So this is the things which I try to correlate our clinical practice, how we can correlate with the ethical principle and somewhere the legal aspect of our practice. Third pillar is non-malfeasance. Do not harm the patient, or whatever do, the beneficence, the interest of the patient is opposite, is the don't do anything which is harming to the patient. It is again relative term over there. A typical example is giving the opiates of the dying patient or about to die, having a terribly pale and maybe a breathing difficulty, but this opiate may decrease the blood pressure, it may hasten the death, but still it will not be a violation of non-malfeasance. So this is the third ethical principle, is whatever you do, you should not harm the patient. Beneficence is in the interest of the patient, because all these things are even important when we really make the documentation. Third one is the social justice. Social justice is the existing scenario. You allocate your resources what is most appropriate for a caring patient. Say for example, if you are practicing end of life care in ICU and one 25-year-old person who met with the polytrauma probably is the more appropriate for that ICU care, you can shift this patient to another care apart from the ICU. It will not be taken as an inferiority or you are withdrawing your services. All four pillars, once you document clearly, nicely, based upon this principle, then obviously there would not be any legality issues about that. So I hope we understand the principle of the end of life care, and now comes to India. What is the Indian scenario as of now? What we have seen from last 10-20 years, and now exactly even nothing much change. Of course, little bit of awareness increase, but general awareness of ethical issues is not very much among the Indian, maybe a general public as well as the doctors. Unbearable economic and social burdens to patients and family. Lack of attention to issues surrounding the quality of dying of critical illness. Most important thing, once we know this patient is not going to survive maybe a couple of days, and typically the healthcare provider or healthcare agency will have a common tendency to, अरे इसका कुछ नहीं हो सकता. Even in our ICU caring team, when it comes to that bag for the handover, अरे ये तो कुछ नहीं आगे. Next patient, we see the next patient, इसका तो ज़्यादा कुछ हो नहीं सकता. Nothing needs to be done. So that's again a problem with this thing, is we are giving the not due attention when the person is dying. They still require a care which is almost as equal to as what we are providing to the other. Maybe direction is different, but obviously they demand care. Confusion of euthanasia with foregoing of life support. Very big issue. Very big issue. I'll discuss in the one or two judgment. Lack of legal clarity or established guidelines on foregoing of life support therapy. Partially true. Now we are having a reasonable clarity after the March 2018. And physician apprehension of being vulnerable to reputation. I place it the last point, but is the first and foremost point. Immediately the person says, कौन कौन फंस जाएगा यार, बाद में केस करेगा, वो इज गोइंग टू डिफेंड आवरसेल्फ एंड जो है जो बोल रहा है कर लो, वट एवर द कंसल्टेशन, वट एवर द यू कॉल द न्यूरोलॉजिस्ट, यू कॉल द नेफ्रोलॉजिस्ट, वट एवर दे से यू कीप ऑन डूइंग दिस थिंग, बिकॉज भरोसा नहीं क्या हो जाएगा. In the court of law, how we can defend ourselves, we can be taken as an active practitioner for the hastening of the death. That is a common scenario. So with this background, I am now moving to the legal aspect of end of life care and foregoing of the life support. Just to go into the little bit the depth of the legal, we must be aware about the video creation, because I require maybe 10 minutes more. Okay, I try to wrap up. So Article 21 is the Constitution of India, which actually defines a right to life and right to personal liberty. That's a very important article which actually addresses all of the rights of the life, right to live, right to have a reputation, right to against the sexual harassment, all these things are there. Where it is applied, right to a life is also having a right to die with the dignity. And it is a contradictory to the section 306 and 309, and that's created confusion over there. 309 and 306 is actually punishable offense of the attempt to suicide cases, where you address this issue in the legal form in the section 309, and these are the important judgments over the timeline. 1994 Rathiram versus Union of India, Gyankor versus State of Punjab 1996, and 2006 the Law Commission report of euthanasia claims, and the most important and the very important landmark judgment over the Aruna Shanbag of Union of India, and lastly the Common Cause versus Union of India. Few I will describe in a just narrate over there, and last is 2018 in the March last year. This came judgment from the Common Cause Registered Society versus Union of India. That's important, where we need to understand in detail, and based upon that we can practice. Rathiram versus Union of India and another, actually they unconstitutionally of the subsection of 309 of Indian Penal Code. So they actually understand 309 should not be applicable in this situation. These patients require a dying with the dignity. But Gyankor is exactly opposite to this thing, what we call is the overruling of this judgment, and they finally say, court held that both euthanasia and assisted suicide were not lawfully valid in India. Technically, the Article 21 was interpreted to mean that the Indian citizen has the right to live, which may not be interpreted as right to die. So that's what where it was there. And the law of this Aruna Shanbag case, where the Supreme Court realized it is required, but this is a 37-year-old patient of the post-rape suffered a severe brain injury, and she was not on the ventilator. So this is a 37 for the persistent vegetative state. Is entirely not at all different what we are talking about. We are talking about the patient which may not survive for the 1 day, 2 day, 3 day or 4, 5 days. This judgment for the 37 years lived with the persistent vegetative state, and this court actually not allowed for the end of life, and we extrapolate all the judgment in our day-to-day practice. So yes. Lastly, this is a piece of our evidence in March 2018, which actually describes it is allowable under the certain condition when the living will is there. I will not read in detail over there because the paucity of time is there, but this is most important. I would request everyone to go through this judgment and then finally decide, because it says only the advanced will and living will is there. Once the living will is there, then you see the patient is really now reached to that state. Then make a medical board. This medical board go to the collector. Collector made the external medical board. External medical board approach to the first class judge over there. and then they finally give the direction you can go for the end of life care after the so much. And technically then again, can we practice end of life care in India with such a really cumbersome procedure, and sometimes we don't even have a time over there. So that's why and sometimes there is a real threat of your fine also. So I summarize with this. So stepwise approach is identify the patient correctly, ensure appropriate situation. Now the patient reached to the end of life stage, make consensus among stakeholder of primary disease and the medical practitioner. Don't a single physician should not activate the end of life. It is required a team of doctor. Review appropriate legal document. Communicate all healthcare of the patient who is caring of the patient. Activity end of life care a process, and probably you should have your institutional end of life care SOP, and do not resuscitation, and the cause of death would be your primary disease process. You can do anywhere in your ICU, non-ICU, home, and even a palliative care. This is a piece of documentation should be maintained. So it actually fulfills all the pillars of the ethical versus the legal issue, legal part where you have all the documentation of your signatures from the patient if there is a capacity to sign it, or surrogates to take the decisions. So key message is foregoing of life support or EOL can be practiced in India. It has been done by the team of doctor. Legal procedure must be followed as per recommendation by Supreme Court judgment of common cause versus Union of India case. Hospital must develop institutional SOP or end of life care. Appropriate documentation is not only mandatory, it is safeguard also, and passionate clinical care must be continued, preferably by the trained healthcare provider. I end my talk with this Roger Bond, a quote: dying can be peaceful, even or a great agony when it is inappropriately sustained by life support. Thank you.
Thank you, Dr. Jeetendra. Indeed, this is a topic which we can go on deliberating for an entire day, but definitely a very... Any questions or comments? I personally would like to say that nowadays in these times when people have money and power, death seems to have become a disease.
True.
So people don't accept death the way they used to. One, I think as far as end of life is concerned, like all critical patients, communication is the most important issue. Legality is there, but to counter those mobs who come to us, even with end of life patients, what we need is a very clear communication, continuous communication between the family and the doctors. And at the end of it, I think hand-holding is something that we will all have to learn. We'll have to be more compassionate, but we are usually compassionate. We'll also have to show the compassion to the family. That will definitely help us.
Exactly, because as Dr. Paltara pointed out, it is not a whole day. It is a workshop for the couple of days to 3 to 4 days. We didn't touch the clinical aspect. My task is the legal aspect only. So therefore, we going for, of course, the very important for the communication, repeated communication, and this thing is, but end of the day, we should be very sure whatever with the agreement of the patient or family, are we doing the thing lawfully acceptable by this law of land or not? Even a third person, whatever you are communicating with the probably 2 or 3 family members, but we face the situations where later on any other family members come up with this thing. So be careful, be safeguard, at least understand the legal aspect of this practice. Of course, the clinical is the most, because we primarily...
I always say, end life to the days and not days to the life.
Exactly.
और ये जो एंड ऑफ लाइफ का जो हम लोग टेक्निकल बात करते हैं तो हमेशा ऐसा लगता है बहुत लीगल प्रॉब्लम्स है, फंस जाएंगे, बहुत डॉक्यूमेंटेशन करना है. आई थिंक एज ए मेडिकल स्टूडेंट आई हैव ऑलवेज थॉट दिस इज द नेचुरल पार्ट ऑफ आवर लर्निंग एंड अंडरस्टैंडिंग एंड टीचिंग. जब हम बच्चे थे तो सुनते थे कि डॉक्टर ने जवाब दे दिया. हम अपने बड़े बूढ़ों को घर ले आते थे या अस्पताल में ये इंतजार करते थे, गंगा जल ले जाते थे. फिर धीरे धीरे ये एक हम जब प्रैक्टिस में आए तो लामा बड़ा पॉपुलर हो गया। जब पेशेंट मरने लगा तो हमने लामा यूज़ करना शुरू कर दिया। अच्छा लामा हुआ, खराब लामा हुआ, फिर डॉक्टर भी बढ़े, लॉयर भी बढ़े, वकील भी बढ़े, कोर्ट्स भी बढ़े और पेशेंट भी बहुत स्मार्ट हो गए या समाज बदल गया, खाई बढ़ गई। मैं आपसे ये कहना चाहता हूँ कि ट्रीट एवरी डाइंग पेशेंट, लुक एट एवरी डाइंग पेशेंट एज योर ओन फैमिली मैन। और आप उस फैमिली मैन के साथ क्या करोगे, कैसे करोगे, वैसे ही उस पेशेंट में करिए। यदि आपको लगता है कुछ नहीं हो सकता, डोंट बी एग्रेसिव। पेशेंट को होप मत दीजिए, पेशेंट के साथ खड़े रहिए, दर्द कम करिए, उसको रिलीजियस प्रैक्टिस करने दीजिए, अपनी बात लिखते रहिए। बहुत टेंशन लेने की ज़रूरत नहीं है। यदि हम सही काम करेंगे, अच्छा काम करेंगे, कोई इलीगल काम नहीं करेंगे, आई एम 100% श्योर, मैंने कभी नहीं देखा, किसी अस्पताल में नहीं देखा कि किसी मरे हुए पेशेंट पे वेंटिलेटर चलाओ। अनजाने में गलतियां होती हैं, लेकिन कोई अस्पताल, कोई डॉक्टर ऐसा नहीं करता, बिल्कुल भी नहीं करता है। लेकिन ये समाज से हमको लड़ना पड़ेगा। लेकिन सबसे ज़्यादा हमें इस चीज़ को श्योर करना पड़ेगा, हम जो कर रहे हैं हमारी तरफ से अच्छा कर रहे हैं और प्रोफेशनली कर रहे हैं, और उसका डॉक्यूमेंटेशन थोड़ा होना चाहिए। हम इसको पिछले 20 साल से प्रैक्टिस कर रहे हैं, कभी कोई प्रॉब्लम नहीं आती। यस सर।
2018 common cause judgment, is it a practical judgment? And how many, from 2018 to now, how many people have signed the lyric will? And if not, why not? Is it a practical judgment?
So you correctly hit the nail. Because paucity of time I didn't discuss this thing is, this judgment is technically understand the things very clear way, what we wanted to narrate through the our legal aspect of the art system. They analyze the things correctly, but they come up the solution which is not at all feasible. That's the important thing which I wanted to say because of the paucity of time. That's why I didn't read word to word over there. Till now we didn't come across the living will, and then of course the absence of the living will, how you go about that. So this judgment is understanding, analysis is okay, but when they came up with the legal solution, you can easily make out it is not at all amicable solution what we are talking about. Usually they are the persistent vegetative. I am not saying these are the rarest of the rare case where the persistent vegetative state is there, but they are not as common. Thousands of the patient dying every day, which qualifies the end of life, and they cannot sustain that. Yes, sir.
Do you have any idea how many people have made a lyric will? Has anybody made a lyric will?
Till now we didn't come across even a single case over.
Okay.
So that's why the answer is that are we allowed in the legal in the India is the legally we can practice end of life or not? Practically no. That is a message.
Thank you, Dr. Jeetendra. We can take the questions later.
Thank you so much.